3, 2, 1!
So guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott Talks Law, and in this episode shall be talking about the trial process under criminal procedure and practice. So we have 15 processes that happen or occur during trial. We have the obligation that either parties have the legal burden of proof and the evidential burden of proof. The prosecuting side has that legal burden of proof to prove a matter beyond reasonable doubt and establish a prima facie case that will require a rebuttal. And we have the choice of witness. The choice of witness, either party can choose a witness to be represented to help in building the case. So prosecuting side chooses witness in the form of PW1, PW2, PW3, witness number 1, number 2, depending on the number of witnesses. So the prosecuting side and the witness side have that right to have witness to help in building the case. And we also have the opening speech, and this opening speech is made by the prosecuting side to just introduce, and the court shall not rely on the evidence that is produced during the opening speech. We have the order of witness. The parties are free to choose the order in which the witness are to appear. We have the examination in chief. The examination in chief is that exercise conducted by the prosecuting side to determine the eligibility of the accused person and or the witnesses called by the defense witnesses. So here no leading questions are allowed. No leading questions that demand particular answers are not allowed. We also have after examination in chief, we have the cross-examination, and the cross-examination is conducted by the defense side, and here the leading questions are allowed, and the defense side is the one that conducts the cross-examination. And after cross-examination, we have the re-examination and exercise by the prosecuting side. So after re-examination, we have questions from the court. The court can also ask questions to the parties or the witnesses, and these questions are not supposed to fill the gaps in the either evidence of the prosecuting side or the defense side. These questions are not supposed to fill evidence. But the court is supposed to make its own inquiries, but not to fill evidence or the gaps that have not been filled. We also have a prima facie case that is established by the prosecuting side. We also have the conduct of the defense case. A defense is supposed to conduct itself by bringing up its defense during the rebuttal. We also have the close of the defense case. We also have calling of further witnesses by court. The court can call further witnesses apart from those that appear to represent the parties. We also have so when the court calls witnesses apart from those present in court by either parties, the prosecuting side or the defense side, these witnesses are to be cross-examined by the prosecuting side and the defense side. So we also have inability to raise a defense due to mental disabilities. It's also another occurrence during trial. We also have the visit of locus in quo, where the court visits the scene of crime to determine the evidence or to determine how the evidence was collected. So we also have final submissions. So a trial process, during trial we have obligation that either parties have. So we have the legal burden of proof that lies with the prosecuting side during the entire proceedings. So the prosecuting side is supposed to prove a matter beyond reasonable doubt and to create a prima facie case that will require a rebuttal. So the legal burden of proof lies with the prosecuting side and does not shift. So the evidential burden of proof is on the defense side, but it can shift depending on the party that is bringing out this evidence. So the legal burden of proof does not shift, as it was held in the case of Willington versus DPP, and also in the case of Dixon Nyakundi versus Republic. And according to the case of Dixon Nyakundi versus Republic, a party has that right to prevent self-incrimination, right against self-incrimination, that should not produce evidence that will self-incriminate you. And also in the case of Boniface Mololo versus Republic, this so the court may direct us. So the right against self-incrimination can be exempted where the court directs to get samples on particular issues. So the court may direct forensic sample or scientific testing, including DNA. So under here, the court can go against that right of self-incrimination, again, according to the case of Boniface Kyalo Mololo versus Republic. So the opening speech, that speech that is covered for under section 300 of the CPC, and this speech is made by the prosecuting side, and the case of Kanyoro Kamau versus Republic. So the failure of the opening speech, of making the opening speech, is not fatal. So if the prosecuting side does not make the opening speech, is not fatal, and the court should not rely or treat the matters in the opening speech as evidence. So the statements made by the prosecuting side during the opening speech are not supposed to be treated as evidence. The court shall not treat those matters or statements during the opening speech as evidence. This is just an introductory part, just a summary of what the prosecuting is going to rely upon, the summary of the entire proceedings. So the choice of witness. So the prosecuting side has the duty to call witnesses to establish the truth, even though the evidence is inconsistent. So the witnesses are supposed to be called to establish the truth of the existence of facts in issue. So the prosecution needs to call witnesses who may have relevant factual information, according to the case of Bukenya and others versus Uganda. So if these witnesses have relevant factual information about the particular case, then these witnesses are supposed to be called to testify. So if this is a theft case and someone has been involved in stealing a laptop, then the prosecuting side will call witnesses that will help in prosecuting the defense or the accused person. So this witness, if there are people who saw this person stealing the laptop, they will come in court and testify against the accused person and claim when they saw this person stealing the laptop, at what place. So these witnesses are just come to help the prosecuting side to because they have relevant factual information. So in the case of Oluoch versus Republic, a matter may be proved by a single witness. It's not necessarily that many witnesses are supposed to appear. A matter may be proved even by a single witness. So facts may be proved by a single witness, but the identification by a single witness should be supported with greatest care. So a fact or a matter may be proved by a single witness. Single witness can just appear to prove a particular fact, but this matter shall be treated with greatest care, a matter that has been proven by a single witness. So there is no required number of witnesses that are supposed to appear. So in the case of Kasam Okiro versus Republic, the prosecution should conduct itself should conduct its discretion in deciding the witness that are relevant to prove the guilt of an accused person. So the prosecuting side is supposed to conduct itself with discretion in deciding the witnesses that are supposed to appear. So the prosecuting side can start with those potential witnesses, those witnesses who have relevant factual information, as they proceed with other witnesses who have little information about that act. In the case of Bare Mohammed versus Republic, insufficient evidence with witness support. So insufficient evidence without witness support, then the evidence of the witness couldn't have favored the prosecution. So the prosecution can, in some instances, have that insufficient evidence. That evidence that is not able to create a prima facie, So if the prosecuting side does not have sufficient evidence, even though they have witness, whether or not they have witnesses, it will not help them in winning that case. Insufficient evidence without witnesses will not help the accused person. Couldn't have favored the prosecuting side. So the prosecuting side is supposed to have that cogent evidence. So the witnesses are just supposed to be called to support the evidence that the prosecuting side that the prosecuting side has. So insufficient evidence without witness will not have favored the prosecuting side. So the order of witness, the prosecuting side is supposed to determine the order in which these witnesses are to appear in court. So as it was said in the case of Roy Richard Elirema and another versus Republic, so there is no law requiring the order of witness. No law is prescribed the particular order that witnesses are to appear in court. So examination in chief is that activity conducted by the prosecuting side to determine the credibility of the defense witness or the accused witness. So the prosecuting side conducts that examination in chief, and during the examination in chief, no leading questions are allowed. So during examination in chief, this is a sworn testimony by the accused person. This is a sworn testimony by the party. So the prosecuting side conducts the examination in chief, and after the examination in chief, you have cross-examination by the defense side, who conducts, and under the cross-examination, leading questions are allowed, and the purposes of cross-examination is to test the veracity of the witness, whether or not the witness is telling the truth. So the prosecuting side comes with his witness, referred to as potential witness number 1, PW1. So this witness is taken through examination in chief, where the prosecuting counsel asked the witness the questions, but not leading questions. So the DPP presents the witness in the examination in chief. The witness testifies on the facts that the prosecution intends to rely on. At this stage, leading questions are not allowed, and testimonies like except in the formal introductory part of the testimony, like the witness name. So in the introduction part of the testimony, leading questions can be allowed where the prosecuting counsel or the DPP asks this witness his name according to section 150 of the CPC. So the leading questions are not allowed except during the introductory part. And the cross-examination is done by the defense side, where the defense cross-examines the prosecuting witness, where the defense side cross-examines the witness, and this is to test the veracity of the witness, whether he or she is telling the truth. So after this cross-examination, we have the re-examination, and this is the exercise conducted by the prosecuting side after cross-examination by the defense side.